Mr. Gilbert, you have Michaela Hayes present.
Ms. Hayes is ready, and Mr. McGrath is mine also.
Oh, I'm sorry. That's right. Mr. Vogler told me that. All right, Mr. Vogler, that concludes your matters then?
Yes,
All right, have a good day.
Yep.
Thank you for the council, the conference in chambers on the other matter, and I'll let you know.
Yes, I appreciate you, Your Honor.
All right, People v. Michaela Hayes, file 25-93360. Council, you want to state your appearances, please?
Zachary McLennan on behalf of the people.
And James Gilbert here on behalf of Mr. McGrath. I'm sorry, wrong file. Ms. Michaela Hayes standing to my right.
All right, and we're here for sentencing on a charge of maintaining a 2-year high court misdemeanor in possession of methamphetamine, a 10-year felony. The advisory guidelines are at 0 to 11 and 0 to 17. Have you had a chance to review the report and recommendations with your client?
Yes, we have had a chance to go over it. We do have a challenge to scoring, but other than that, no additions or corrections.
Okay, and Mr. McLennan, any additions or corrections to the report from the people?
No, Your Honor.
Okay, your scoring challenge, Mr. Gilbert?
Your Honor, just the one, and I don't believe it changes the grids, but I just wanted to point out, she's currently scored on both of these on OB 15 for 5 points. My understanding that would, to get those 5 points, that it would have to constitute trafficking, which would mean that the items would have to be then being sold so for further distribution. And my understanding of the police report in that is that items were sold to a CI or to another individual, but there was nothing in the reports that I saw that that individual intended to distribute.
Okay, Mr. McLennan, your response?
Your Honor, when I reviewed OB 15, I was reviewing for the offense involving delivery of methamphetamine. So I thought it was properly scored at.
Yeah, the statute does allow for the scoring of 5 points. It says the offense involved the delivery or possession with the intent to deliver marijuana or any other controlled substance or a counterfeit controlled substance, or possession of controlled substance or counterfeit controlled substance having a value or under such circumstances as to indicate trafficking. From the statutory language itself, the modifier having a value or under such circumstances as to indicate trafficking, it's unclear whether that would apply to the entire sentence or only to the last part, the possession. The Michigan Supreme Court, in a published order, I don't remember the case name, did limit that modifier only to the possession part. So it would be scored where the offense involved possession under such circumstances to indicate trafficking. Here, there would be no circumstances indicating trafficking, which would be delivery to a person for further distribution to others. However, I agree with the prosecutor that both of these sentencing offenses involved, there were 2 controlled buys. So the offense, it's not limited to scoring it for delivery sentencing offenses, but it says where the offense involved the delivery. And here, both of these are pled down from controlled buys. So both of these sentencing offenses did in fact involve a delivery. And the Supreme Court's interpretation means that the trafficking limiter doesn't apply in that circumstance. So I would overrule that objection and leave OB 15 scored at 5 points for both counts. Any other scoring challenges from the defense?
None, Your Honor. Thank you.
Any scoring challenges from the people?
No, Your Honor.
All right, Mr. Gilbert, anything you want to say?
Your Honor, with her scoring, and I do believe this is a situation where Ms. Hayes, her and her husband or significant other got wrapped up in drugs, and she does need to address these issues. We're in support of the recommendation. We'd ask for a term of probation so that she can address those things. Ms. Hayes has been nothing but a joy to work with since I was assigned to this case. From day one, she acknowledged she had culpability in this case, and what she had done was wrong, and that she needed to address these issues. And so I would ask that the court follow the recommendation, put her on probation, and hopefully she can get any types of addictions under control. Thank you.
Thank you. Ms. Hayes, you don't have to say anything today, but you're welcome to. Is there anything you want to tell us? Or okay, Mr. McLennan, any recommendations?
Yes, Your Honor. Defendant's 25 years old and has 2 prior misdemeanors, no felonies. She's young, and it looks like she's completed some inpatient rehab and tested negative for drugs in November. a young mother with kids, and the plea and the delay was structured in this case to give her a chance to be a good mom to those kids and succeed at life and help them succeed. So, Your Honor, I think the recommendations are appropriate and the people support them. Thank you.
All right, thank you. Well, Ms. Hayes, this is a very serious case involving, some controlled buys, and, I'm sure you're just as aware as everybody else that your co-defendant got a prison commitment on this, and you're just as involved as he was here. And so you should be very thankful to the efforts of your attorney and to the good graces of the prosecuting attorney that you also aren't going to prison today. I think given the family circumstance, there's the CPS case that's ongoing. You did complete the inpatient treatment. I think under all those circumstances, as well as what's laid out in the pre-sentence report, the plea agreement calls for you to delay your sentence for up to a year. And if you successfully complete probationary terms during that delay, the possession charge will be dismissed and will be at sentencing on the maintaining charge a year from now. I think that is appropriate under all these circumstances. So I'm going to delay your sentence for a year, and during that delay, place you on a probationary term supervised by the Department of Corrections, subject to the terms and conditions listed on pages 2 and 3 of the pre-sentence report, including outpatient or residential substance abuse treatment when referred. They include a crime victims assessment of $130, court costs of $350, $136 in state cost, comply with DNA testing and pay a $60 fee. There's a monthly supervision fee to the Department of Corrections. This is a statutory delay of the sentence. So we're not going to give you your appeal rights right now, and you're not eligible for early discharge from that probationary term, because legally what we're doing is we're just postponing your sentence for a year, putting you on probation in the meantime, seeing how you do. If you do well, then we'll come back for sentencing only on the maintaining charge. Okay. If you violate terms of your probation, including getting new charges or not complying with treatment, then we'd come back early for sentencing on both counts. Do you understand that?
Yes.
All right. And Agent Lesky, do you want her to stick around to talk to you today?
I'm just gonna give her a sheet to come see me.
Okay. All right. So go stop by and get a note from Agent Lesky, and then you have to report to her. Okay. Okay. Good luck to you.
Thank you.
All right, let's go off the record for a second. Toby Gagnon, file 25-93371FH. All right, counsel, you want to state your appearances in this manner?
Zachary McLennan on behalf of people.
And Your Honor, James Gilbert here on behalf of Tiffany Ganon.
All right, and we're here for a docket call, and also we did a show cause for Ms. Gagnon's failure to appear last time we were here. What's I guess, how do we want to proceed on that?
Well, I guess I addressed the show cause first, Your Honor. I did talk with Tiffany, and she told me that she did have the wrong date and time, that because she was also in the Sunrise Center at that time, and that they'd given her the wrong time to be here. I can tell you that when we left court, Sheriff Brubaker assisted me in making contact with her, and she immediately was in contact with me, saying she didn't know about it and it was nothing that she was trying to hide. And so I would ask if the court could possibly set aside the show cause.
Mr. McLennan, any objection or different information about that?
No, Your Honor, she's otherwise been reliable.
All right, I'll dismiss the show cause, and she is present today. So in terms of docket call, where are we at on that?
Your Honor, that hasn't been resolved. However, she is doing very well from what I understand, and I think that would probably affect what the prosecution wants to do. I believe she's successfully completed inpatient and is residing with her mother and doing fine. So yes, when her and I talked over the weekend, she is back trying to get her GED, I believe.
I'm maintaining all A's, like.
All right, well, any objection by putting it to the January docket? All right, I can do that, but I guess I'll say I disfavor using our pretrial system to just have sort of this pseudo probation because she doesn't have the benefit of a probation officer and supervision. So if we know what we're offering, let's get her on supervision and let her do these things while on probation. So if, you know, if we're not resolved in January, we should probably be setting trial.
I understand.
Because on bond, they're left to kind of white knuckle it on their own efforts. And I much rather if somebody's wanting to make changes, have the benefits of a probation agent that can connect them with services.
We will have the matter resolved by January.
Okay, so we'll come back on January 5th at 10:50 a.m. And that concludes our morning docket. Be adjourned.
Thank you very much.
Then that brings us to People v. Joshua Pritchette. File 25-93370. And Mr. Gilbert, what's our status?
Your Honor, the prosecution has presented us with a plea offer, which is very tempting to my client. However, there is a substantial restitution amount, and we're asking just so my client can attempt in the next make sure he can satisfy that. We're asking if you could possibly put this on your February docket, and hopefully we can have it resolved at that time, and any restitution matters can be resolved.
Any objection to that, Mr.
No, Your Honor.
All right, well, let's put it on February 2nd at 9:20 a.m. All right, Mr. Pritchett, we'll see you then, sir.
Okay, thank you.